Thank you very much for having me. I'm very excited to be here. So my job is to talk to you about online mediation, but thinking about it through the lens of domestic abuse and why we use online mediation, where we use it, what does it offer us, and what as mediators are we seeing as a result of using online mediation. Can I go to the next slide, please? So just a little bit about me, because I'm conscious that probably nobody knows me other than Lisa. So I am an accredited family mediator, but I've spent many years working in children's services where I oversaw a portfolio of services, including safeguarding, serious case reviews, which is a review that we do upon child death or serious injury, early help, restorative practice, and I also looked after domestic homicide reviews for the local authority. I am a restorative justice practitioner and have practiced in prisons and in the community delivering restorative justice interventions. I'm a restorative practice practitioner and still work as that, a family group conference coordinator and mediator. And I also co-authored the report, What About Me? A Child's Right to Matter, which is the report that Lisa was just talking about, which is where the biggest recommendations that came out of that was the need for children to have somewhere to go to understand more about their rights and information when they experience parental separation. So my job today is to explore, I suppose I split it into pre-pandemic, post-pandemic, because pre-COVID-19, most mediation was face-to-face. Most people didn't practice online. It wasn't common at all. Post-COVID-19, it's completely different. So if we can go to the next slide, please, I'll explain it a little bit more. So family mediation historically was always face-to-face, online was rare. Family mediation now is generally always offered as an option for being online. In fact, some companies only mediate online over here now and don't offer face-to-face services. Most companies offer a hybrid approach where they do both. My job today is to talk you through some real life case studies that I have mediated and talk you through the risks and the outcomes and the barriers or the positives about facilitating them online. So next slide, please. Thank you. So the first case study, to give you a little bit of an overview, was physical and emotional abuse and coercive control in the relationship. This was disclosed to me as a mediator in what Lisa described as previously as the mediation information and assessment meeting. So our one-to-one meeting before going into a joint mediation process. They had been to court and there had been further controlling behaviour that had been displayed throughout the court process. So the domestic abuse had not stopped post-separation and had not stopped whilst going through the court process. There had been lots of court applications over the last 3 years. A child arrangement order was in place, but the father would consistently make more applications to court to vary the order. Mum would say that that was a way to control the situation and to push the boundaries. In the end, a judge said, I can't keep hearing your case. I don't want you here. You need to be able to work through some of these things together. Mum was a police officer and she actually worked in the child abuse team, and Dad was a secondary school teacher. The child was 5 years old and this had already been in and out of court for the last 3 years. So it was Dad who made the application to mediation. Firstly, he said because he wanted another certificate to be able to go to court and make another application. But actually what ended up happening was that they came into mediation. Could we have the next slide, please? Thank you. So how did we facilitate the mediation? So this had to be really carefully thought through. And in my head, I was very conscious that the domestic abuse had not stopped post-separation. So we had to create an environment that felt productive and safe. Mum wanted to mediate. She felt as though the court process was not where she wanted to be. It had not offered them anything over the previous 3 years, that she wanted to try and have a different type of conversation to see whether or not that could shift whatever it was that was happening around their child. Before we came into the joint mediation space, some things that were important for me to consider was that I was only prepared to mediate if they were over separate spaces. That's often referred to as shuttle mediation. And that is where they sit in separate spaces and the mediator goes between those two spaces, sharing the information with each other. That I felt was a good safeguard for both of them because there was no direct communication between them. I would be able to summarize, reframe, challenge, and engage them in a slightly different way. I felt it was only appropriate to move forward with if the case was co-mediated. So there was 2 of us facilitating the process. And that is because I had to be really conscious that I did not want to be a vehicle of further abuse. So to have 2 of us consciously thinking about the dynamic, the words that were being shared, and how we were facilitating the process felt really important. The other thing that felt really important was that there was no real clear agenda from Dad as to why he wanted to mediate or as to why he wanted to make another court application. It didn't seem that there was a specific reason. So we had a series of preparation meetings before going into the joint session. And part of those preparation meetings was about establishing a clear agenda. What we didn't want was for Mum to go into the mediation room and have no idea what Dad was going to ask for or say or bring up on his agenda. Both of them needed time to prepare for the mediation space, given the emotional challenges that had been in place over the last 3 years and indeed prior to that during the relationship. During those preparation meetings, we also spent some time setting some very clear expectations of the mediation process. So we have very clear code of conduct in mediation that we reiterate in something called an agreement to mediate, and it allows us to set a clear foundation. We had to go a step above that and think about actual ground rules within that space, what was appropriate and what wasn't appropriate from our perspective as mediators. And we also had to think about a post-mediation safety plan because this is a vulnerable scenario. Both of them wanted to mediate. We had to give them that opportunity, but we had to create the right safety around that process. So Mum was engaged with a domestic abuse coordinator who was available post-mediation for Mum to be able to speak to, but also for the 2 of them to work together to see what other safeguards might be put in place for Mum following the mediation meeting. Could we go to the next slide, please? So the outcome, what happened as a result of the mediation? So the mediation, surprisingly, was successful. They got an outcome. To give you an idea, the specific conversation was actually about schooling. So they, Dad wanted to move location and therefore wanted to discuss the child's school. And the threat of moving location had been something that had been in the air for a long time. Us using the preparation meetings to really identify what it was that they wanted to discuss also meant that Dad went away and prepared a geographical area that he was considering moving into, and that he had found houses in. So it allowed Mum to have a real idea about what we were talking about in respects of where Dad was going to live, where Mum was living, and therefore the schools that might be an option. I should probably say that they had an arrangement that was a shared care arrangement where the child spent equal time across both households. They came out with a parenting agreement. So I drafted all of the outcomes that they had agreed during the mediation forum. And they also requested through the court for that to become a consent order. So a legally binding agreement between them. I actually got feedback from Mum in that case, where she shared that she felt very seen, she felt very heard, and she felt as though the balance in the mediation space had been very even and rebalanced from what she had previously experienced. So a positive outcome. I haven't seen them since, so I'm guessing that this is a really good thing, and I'm hoping that means that there hasn't been any other applications that have gone into court, or indeed the need to see a mediator since then. Could we go on to the second case study, please? Thank you. So again, this was a domestic abuse case. So domestic abuse was disclosed to me during the initial preparation meeting. Dad had actually been convicted for the physical assault against the mother and had served a custodial sentence. So it was serious enough that he had served a substantial amount of time in prison as a result. There was also a restraining order currently in place so that Dad wasn't able to go within a certain distance of Mum's house, or indeed Mum, or contact Mum in any way. Dad was known to what we know as MAPA, which stands for Multi-Agency Public Protection Arrangements. And he was classed as high risk. So what that means in practice is that there are multi-agency professionals that are concerned about Dad's risk to Mum and potentially other relationships moving forwards. That gives you an idea of the severity of the domestic abuse. Again, Mum was the one that actually made the referral to mediation. She really, really wanted to mediate. And she felt as though leaving the decision about their child in the hands of a stranger, her words, not mine, left them all feeling very vulnerable, and that she wanted desperately to reclaim the narrative between them and to have a different conversation and hopefully find an outcome. Mum knew that court was an option, and I will always say to anybody, sometimes court is needed, and in those cases it's the right place for people to be. From her perspective, it was the last option, it was the last approach. She had a very specific view on that. So we explored the option of online or face-to-face mediation. Now, I assumed we would go for online because I thought that's probably the easiest way for me to create a safe environment to mediate. However, Mum was very clear with me that she wished for the mediation to be face-to-face. She was particularly worried about the influence of Dad's new partner. And with being online, she didn't feel that she could be completely assured that Dad's new partner wasn't in the room. and therefore telling him what he should or shouldn't say. And she believed that that would escalate issues post-mediation. So unlike the first case study, the domestic abuse had stopped. She hadn't experienced it since he had been released from his custodial sentence. But the new partner had been sending aggressive messages to mum. So she felt it left her vulnerable with the new partner to be online. There were safeguarding concerns as a result of the domestic abuse. They had been known to children's services for a fair while, and they also had an allocated social worker. So could we go on to the next slide, please? Thank you. So safety planning, as you can imagine, there was a lot of thought that went into this mediation, and a lot of considerations. I mean, I don't think I could list all of the thought processes, so I've just picked the top ones to list. So we had to have permission from the court in order to facilitate this face-to-face mediation because there was a restraining order, and there also, as part of the MAPA, the multi-agency public protection, there was a safety plan in place that mum and dad would not ever be put in a scenario where they were in the same room. So we had to get permission to have them in the same room. In order to have them in the same room, we had to have police officers in the corridor of the venue. We also had to have the social worker present, because they were open to children's services. The social worker was there to ensure that the bottom line, in respect of safeguarding, was adhered to in any plan that was created from mediation. It had to be co-mediated. That was one of the restrictions that was a must in order for us to mediate. And again, for all of the reasons that I previously explained. We had 2 separate breakout rooms that were actually in different directions in the building. So if anybody needed any space, they were able at any point to go to a breakout room. We couldn't have them next to each other in case they saw each other down a corridor, and they weren't with the professionals. So they had to be over opposite sides of the building. We had to consider how mum and dad arrived to the building and how they left the building. So we picked a venue with 2 separate entrances and exits and 2 separate car parks at either side of the building. And they were given very clear instructions about who was to arrive where and how. One mediator met each party at each entrance and escorted them out to the exit. And we were also accompanied by a police officer each at both times to try and safeguard everybody. We mapped out very clearly if anybody needed a break. Both of them smoked. So if anybody needed to go for a break, where they went for a break and who would go with them when they went for a break, and what we could or couldn't say in those moments, because we still had to respect our code of conduct with not engaging in those conversations outside of the mediation room. So we had to be really, really clear with everybody what our parameters were. And there was clear ground rules and agendas created. We also, as mediators, had to be very conscious about the language that we were using within the mediation space and how we challenged what we felt wasn't okay if we were hearing things that wasn't okay. So we used lots of Dr. Marshall Rosenberg effective statements, reframing, trying to focus on need of the child, voice of the child, and how we start to create solutions rather than allowing them to get lost in a position, which had been the case up till now. Next slide, please. So what was the outcome? It was a long meeting. I remember that very clearly. It was a very long meeting. There was lots of breaks. It felt really slow to start with, and there was a lot of nerves. You could feel the atmosphere in the room was extremely tense for a good hour before people settled into the conversation. I should probably say that one thing that really helped was that the young person in question, so the child in question, had created some posters for us to put up on the wall. And they were absolutely brilliant and a really funny talking point for everybody. And that was the one commonality that we all had. That was the one thing that we were all there for, which was the child. And I felt like that really helped us in the moments of tension to refocus the conversation around the child. Without those posters, I'm not sure that I would have been able to do that quite as easily. She was too young to really engage in a child inclusive process. So doing the posters was another way to get a voice in the room. So other than it being a really long meeting, they did reach an outcome. The outcome did not breach any safeguarding worries. It did not breach the restraining order. It was a very, very clear plan on how the child and the father can maintain and build a positive relationship. The social workers supported the plan, and it was actually built into their child protection plan. So normally you have a child protection plan, and then you probably have something that they agree together around contact or a parent's time with a child, and they sit quite separately. In this case, they had to be intertwined. They had to sit together because there was too much risk for them to be seen as two separate plans. So the social worker built a lot of the plan into the child protection plan. And to be really clear, we did not resolve a forevermore. This is a stepping stone approach. This had been such a difficult situation that we were just looking at small steps in a direction to create safe and positive relationships for the child with both of her parents. And I often think to myself, what might have been different if it was online? And a lot of my work is online, a lot of my work. And I don't know if that would have worked if that was online, that mediation. There was something about needing the space to feel different, to have a different conversation. There was something about the child's posters on the wall. There was something about how it was planned in that face-to-face scenario that created something really special. I think that there is a place for both in our world. And I think that a mediator considering what the benefits or the barriers might be of both is really important. So online mediation and some considerations that I suppose have been raised through those case studies so far. For me, something really important is we have an hour or so, mine are always longer than an hour, but a minimum of an hour to build a rapport in a mediation, information and assessment meeting. That is not long. That is not long to understand the situation, to screen for any safeguarding concerns, to talk about relationship, potential domestic abuse, safety aspects involved in that, to share information about mediation and everything else that's available to them. It is not a long time. If there is potential for child inclusive mediation, to start sharing the parameters of that so that they can go away and have a think about that. So a mediator has got to be very clear and boundaried. And I think, Lisa, you mentioned it, warm and open with their questioning in order to build the best rapport that we can, because they have got to trust us that we can hold that space in mediation, that we can create the right environment for the right conversations. And I will always say, you have to trust the process and you have to trust your mediator, because we will do our absolute best to facilitate this process in the best way possible, but you need to allow us to do that, which means that we have to get to know you really quickly and build that rapport really quickly. How we screen for domestic abuse is a really important thing. And remembering, as Lisa pointed out in her presentation, domestic abuse isn't just physical abuse. It's far beyond that. And how we go from those kind of open questions to filtering that down to really understand what is beneath the behaviour or the position perspective that we are seeing in that initial assessment meeting. And sometimes I use things like scaling questions, because that can be really helpful on a scale of 0 to 10. If 10 is that we have brilliant communication, we've always communicated really effectively. If somebody gets cross about something, we work that through in a really simple, positive way. And 0 is, it's terrible, I'm terrified to say anything, I really don't know how to bring anything up with them, and I'm really scared to have that my voice won't be heard. Where are you on that scale? And then start to understand a little bit more about that. And I can find that's really helpful for my notes as well, to prepare myself for going into mediation. Safety planning online. I think that safety planning is sometimes more important online than it is face-to-face, because you're not holding them in a physical space. So thinking about, are they on their own in the space? Do they live close to each other? Do they have anybody that they can potentially see after the mediation, if there's a domestic abuse coordinator or somebody like that that can see them after the mediation? How do we start to think about a virtual space and safety planning for that, as opposed to the physical space? The biggest barrier for online mediation is around confidentiality. It's really hard to know if somebody is really in their own space, on their own. Something that I do as standard at the beginning of mediation, and I will explain this in the initial assessment meeting, is to ask them to pan their laptop around the room, or their phone, or whatever it is that they're in, so that I can be assured that they're on their own in that space at that time. You also get really good with body language. If somebody's constantly looking up from their computer, or looking across into the kind of hidden space next to them, I will ask them, I will challenge it, I will be very honest, and I will remind them that it needs to be a confidential space. Separate space mediation online is much easier than face-to-face. It's very tiring for a mediator when it's face-to-face, because you're walking in between those rooms. It gets my steps up, but you're walking in between those rooms. Whereas when you're doing it via Zoom, it's actually a really slick, easy process. Co-mediation, I think co-mediation is much easier online. I'm really picky about the mediators that I mediate with on certain cases. We've all got different strengths, and some of them live the other side of the country. So it's brilliant to be able to do it online, because it means that we can mediate together. And I will always try and bring people in that have a different background to me, so that we can complement each other in that space. And I'm writing an article about this at the moment, but it means that the participants get to choose the right mediator for them. And I think that's really important. I think you've got to trust your mediator. I think you've got to know that they've got the right skill set for your case. And I think you've got to trust that they'll be able to move you towards an outcome. When you mediate purely face-to-face, you're kind of stuck with the geography that you've got. I live in the villages. There's not many mediators. People are kind of stuck with me if they want to do face-to-face. Whereas online, you've got much more to choose from, and you can really start to pick the right mediator for you. We also have the ability to invite other professionals into the mediation space, which may be an independent financial advisor. I'm doing one next week, which is, I think I just saw a question. I'll answer that question in a minute. You read my mind, it comes up. You might, next week I'm doing one with solicitors who will be present. This is often called integrated mediation or hybrid mediation. And again, being online gives you the ability to manage people's diaries a little bit easier to bring them into the space together. The one that I'm doing next week actually has mum, dad, mum's solicitor, dad's solicitor, and paternal grandmother, dad's mum, and her solicitor, and 2 mediators. To try and get us all face to face would have been a logistical nightmare, but to do it online has been a much easier process. Next slide, please. Thank you. So again, important considerations. Everybody needs to feel safe in the mediation forum. We are not there to make anything worse. We are there to facilitate conversations, to hopefully move them towards a mutually agreeable outcome, something that is meaningful and sustainable. One thing that always strikes me is that I often get people that have been to court and got child arrangement orders, but because there is no ownership of that, sometimes what we don't create is something that is sustainable and meaningful to them. One thing mediation is really good at is reality testing. And we start to find that something that seemed brilliant when we said it actually doesn't work for that child's reality. You don't get that process necessarily using other means such as court. Considerations about background on the screen. This is a really important one that I had totally underestimated until I facilitated a mediation where the mum had a massive picture of her new partner and their child in the background. And dad was automatically thrown off, and it really, really shook him and the process. And so I had to put them in separate spaces and then ask for mum to move into a different space in her room so that there was a blank background behind her. It can also be used to control as a means of abuse, dependent on what it is that is behind them. Power imbalances and how they're managed online versus face-to-face. I think the question that came up was about body language and non-verbals. This is much harder online, unless you're like me, because I think you can absolutely tell what I'm thinking by my face, and I talk a lot with my hands, whether I'm on screen or in person. But you absolutely lose so much of the understanding behind the verbal. So I'm very clear with people in the information and assessment meeting that if we're facilitating this online, it's very important that they are given and that I give them the right opportunity to be able to verbalise their feelings and their emotions in that space, because I cannot read that as easily as if I'm in the room with them. So I would say I facilitate it differently if I'm online to if we're in person. And I am very aware that is also a positive about having a co-mediator. So that co-mediator, whilst I'm talking, will be watching the screen, picking up on any of those small movements. You know, an eye roll can be really powerful on Zoom because you are all looking at each other's faces, whereas actually face to face, an eye roll could be lost. So some things that you lose with being online, you also gain other things with being online when it comes to body language. So I think it's just, for me, it's about how we facilitate it. And for me, it's about shifting our facilitation style to understand the difference and the nuance of being online versus being face to face. And then how we manage the process for me is slightly different. For instance, if there is conflict in the space and we are together face to face, my non-verbals may be able to shift that and calm the scenario down without me needing to say very much, because they are reading my body language as well as me reading their body language. When we're online, it's not as easy for me to do that. And sometimes, unless you shout really loud, your voice is not going to be heard. So I have to be really expressive with my body language so that I can draw that back to me for them to be able to hear me. And again, it's shifting that facilitation style. So I think that there are things that are lost with being online, but I also think that if we start to be conscious of that and shift our facilitation style, we can actually gain positives in other areas from being online. Could we go to the next slide, please? Which is it's a last case. I didn't know whether I would have time to do it, but I'm guessing it'll only take me 2 minutes, and it's a slightly different case. So I thought it might be good to hear. So this is a case which was a special guardianship order. So maternal grandmother had been given care of the child. The child had been removed by Children's Services as a result of the domestic abuse from dad to mum, and had lived under a special guardianship order with grandmother ever since. Again, father had served a custodial sentence for domestic abuse. And obviously that was the reason that the child was placed into grandmother's care. So the mediation that took place was actually between father, mother, and maternal grandmother. And it was about father's time with the child post custodial sentence. So in that scenario, and the reason I bring it up, I had to do a mediation information and assessment meeting with all 3 people. So I had to meet maternal grandmother, I had to meet father, and I had to meet mother. My considerations within the mediation space wasn't just about how I keep one person safe from another person. It was about how I kept everybody safe within that space, and also how we got everybody in the same space. And online mediation was definitely the only way that was going to be able to be possible in this case, because they were in 3 completely different geographical locations. And we also had a lot of other risks surrounding this case. There were other professionals that were involved, which were social workers, probation officers, and drug and alcohol services, all of which were spoken to as part of the mediation process. And the social worker and probation officer were with me during mediation. So it was separate space mediation, shuttle mediation, online, with the social worker and probation officer present. When I say separate space, I'm talking about 3 separate spaces. So we have mum in one space, maternal grandmother in one space, father in the other space. There was a lot of impact-informed conversation. This was the first time there had been a conversation since the father had received his custodial sentence. So it was really important that dad wanted to go from nothing to every other weekend and 2 nights during the week. But actually it had been a long time since he had seen the child. So it was really important to focus conversations in putting yourself in the child's shoes and thinking, actually, what is right for them? How do you start to slowly redevelop, reestablish that relationship? It is too much to go from A to Z. I'm sad to say that we didn't reach a final outcome in that mediation. there was too much. It was too much. It was too hard for them to get to that. They needed a different type of intervention. And so what we did was Dad wanted to make an application to court. So what we did was we shifted the agenda of the mediation space, and we used it to think about, from now until you get your first hearing in court, what happens? Because otherwise we are potentially going 3-6 months, maybe more, with still nothing for that child in respects of their relationship with you. And then we are even further back by the time you get into the court arena. So we started to think about the first stepping stone would be some letterbox contacts. So Dad was going to start to write to the child. There would be pictures sent from maternal grandmother to Dad, and then from Dad to maternal grandmother to show the child, and start to just refamiliarize themselves with each other. And ultimately, how that goes, I hope, starts to shape the plan that they see long term coming out of the court arena. And I suppose this case is important for me to highlight, to say that mediation is not a magic wand. It is not the perfect solution. And in this case, it was not the long-term solution, but what it gave these people was something to prepare them into the process that would create the long-term solution. And sometimes that's just as valuable. We get lots of people that come to just the MIAM, the mediation information and assessment meeting, and feel that that has been a really valuable experience, that actually they're able to resolve some of those conversations without needing mediation. So it's not always the solution that is needed. Sometimes it's some of the other stuff that sits around that. And the last slide was just my thoughts on mediation, on online mediation. Obviously, I love mediation, but online mediation. And I think it's got a really positive place. Actually, I do think it has a really positive place. I know that in other restorative interventions, it may not work as well as it does in family mediation. I think it gives us flexibility. I think it gives us a different level of safety, potentially. And I think it gives us a way to be able to facilitate different conversations. Do I think it's a catch-all and should be done in all cases? No. I think it should be individual, case dependent, but I absolutely think it's got a place to stay, especially where there is domestic abuse in the relationship. Thank you very much, everybody.
Jā, paldies, Karlī. Tiešām bija ļoti interesanti un ļoti praktiski. Un mums ir jautājumi. Pirmkārt, pirmais jautājums, kas mums ir, vai vispār, kā jūs uzskatāt, vai vispār jums būtu iespēja tik kvalitatīvi strādāt, izmantojot visus savus paņēmienus, gan tehnikas, gan metodes, kurus jūs pārvaldat kā mediātors, ja jums nebūtu šīs pirms mediācijas informatīvās tikšanās?
If I didn't have the information and assessment meeting, do I think that I would be able to facilitate? Do I think I would be able to facilitate mediation in the way that we do? No. If I had it my way, we would have much more preparation going into a mediation meeting in some cases than we do. But I don't know how you feel, Lisa, but I think that the mediation information and assessment meeting is an absolutely crucial part of the process.
No, I totally agree. And sometimes I would continue like that and have further separate meetings and not move into joint because they needed more separate time, one-to-one. Yeah.
Yeah. And to give you a context, we've now got mediation information and assessment meeting standards in England, which basically outline that it shouldn't ever be less than 45 minutes, but ideally an hour, that we need to cover certain things within that meeting to make sure that everybody is getting the right meeting before going into mediation.
jautājums. Kā Anglijā tiek apmaksātas pirms mediācijas konsultatīvais darbs un kurš par to maksā? Vai arī šādas tikšanās notiek bez maksas? Šis jautājums tiek uzdots tāpēc, ka mums Latvijā nav definētas obligāti šīs pirms mediācijas informatīvās tikšanās.
Carlie, you answer. Carlie.
In short, they are the client is. So the charges massively vary across the country. I'm fairly cheap, so I charge I normally charge £100, which includes a certificate for court if that's what is needed. But they range from kind of £90 to £300.
Carlie, is there no legal aid available for the Yeah,
so legal aid is available. So we've got two types of funding in England, which is Ministry of Justice vouchers and legal aid. The Ministry of Justice vouchers do not cover the pre-meeting. They only cover joint mediation meetings. Legal aid will cover the pre-meeting for both participants. If one is eligible, it covers it for both participants. And then it covers one meeting for both of them and the rest of the meetings for the person that is eligible for legal aid. To be eligible for legal aid, you have to meet certain criteria. If you are eligible, you go to a legal aid mediator and they will sort all of the funding out for you. If you're not, then the participants pay for the assessment meeting. And actually, I think it is a really valuable experience, whether or not mediation proceeds or whether they then choose a different route to go down, because our job is far wider than just preparing them for the mediation forum.
Jā, paldies. Tad vēl mums ir jautājums, uz kuru jūs gan sniedzat atbildes stāstot savā prezentācijā, bet tomēr jautājums mums eksistē. Kā mediātors var lūgt pārliecināties, ka virtuālajā telpā neatrodās neviens cits, izņemot pašu pusi?
It's a good question. I think there are some things that we can do to help. Panning the camera around the room is a good start, and I will prepare people that will be what I ask them to do when we come into the mediation forum. Watching out for body language, that's probably the best tool that you have. Watching people look over a screen or next to them and being very, very clear on your boundaries. I will challenge that if I see it, and I will question and ask and remind. They sign something called an agreement to mediate, which clearly states that they have to be in the room on their own unless given permission. So unless both people give permission for somebody else to be in the space. So for instance, I have done a mediation recently where both have asked for their partners to be in the space. They're long-term partners and they've been separated for a long time. In that scenario, they've both given permission and that's okay. Where permission hasn't been given, it's panning the camera around the room, challenging if you see any body language that you think, actually, I feel that somebody else might be in the room, trusting your instincts as a mediator, and then also reiterating at the beginning of the mediation the importance and why they need to be in the room on their own, which is that they're here to talk about their child. And this is having respect for each other as parents and respect for the process that they've entered into.
You can ask them to open the door as well, in case there's somebody listening outside. And particularly if you're talking, say, with a teenager, you can ask them to open the door to make sure that there isn't a parent listening just outside or another child. And so I think all these ways help to be very careful about that.
Yeah.